people will need to use it for references. Now, if you hear your name and your date of birth, please, you can come up. You know that you're a member of the next panel and the last panel for today, before we have our last keynote speech and then the details for the cocktail of this evening. Like I said before, I'm not going to release the address, the location, in case people start leaving for the place well before the due time. And I know that is possible because today is Friday, and we know what happens on Friday afternoons. The panelists of the fourth panel, you are invited. So as I said before, if you hear your name and your date of, sorry, not date of birth, just your names, please come up. Dalia Hussein, and this group is going to be moderated by Sami Kurebi. Sami, you want to come up, please? Victor Mugabe, Rwanda Kiak, Lina Law Amana, arbitrator and permanent committee member of CIMAC, Cameroon. Datuk Sandra Raju, Director, Asia International Arbitration Center, Malaysia. Slovana good. Vasileva, Secretary General of the AFSA International, and Kajak, South Africa. Bala Galma Godana, Permanent Court of Arbitration Representative in Mauritius. And Funmi Iyai, partner at Templars and a director at Lysiak, Nigeria. Are we all there?
Yeah.
Okay. Over to you, Sami.
Thank you very much. Thank you. Good day to everyone, and thank you for staying for the last session. We now we stay in between you and the cocktail reception for later. My name is Sameh Werbi, and today here in my capacity as I've been invited by the AFA Organization Committee to moderate the session in my capacity as president of the Afriqiya Arbitration Forum, which is a new established arbitration platform to promote arbitration practitioners in North Africa. And I'm happy to represent this forum and to provide you with any information later if you wish about the creation of this arbitration forum. As I said, I'm very grateful to AFA for inviting me to be today in Cape Town and to moderate this prestigious panel featuring a lineup of exceptional speakers and representatives of prestigious African and international arbitral institutions. The topic of today, our last panel, is to delve into the following subject: fostering the future of African arbitral institutions, best practices. Let me first start by introduce our speakers. I have to tell you that few speakers couldn't join, and this is beyond the reasons beyond their control. Two speakers couldn't get the visa, unfortunately, and one of our speakers, she was supposed to land this morning in Cape Town, but I don't know, for any reasons, the plane was diverted to Durban, and she's in Durban, she cannot join either. And we hope that at least Dalia Hussein from the Cairo Center and Funmi from Nigeria will be joining our meeting virtually. Dalia, who's supposed to join and she couldn't get her visa on time, she's the Deputy Director of the Cairo Regional Center for International Commercial Arbitration. And we have today with us Victor Mugabe, who is the Secretary General of the Kigali International Arbitration Center. And next to him, we have Svetlana Vasileva. She is the Secretary General of the African Foundation of the South African Africa, AFSA. And Funmi Iyai, she's supposed to join virtually She's the director of the Lagos Chamber of Commerce International Arbitration Center and the former chief executive of the same institution. We have the pleasure of having with us Mr. Taduk Sundra Raju, who came along from Malaysia, the director of the Asian International Arbitration Center, and Lina Lor Amanu Prizo, who's stuck in Durban, and she couldn't join on time at the conference today. She's an arbitrator and the permanent committee member of the Centre de Médiation et d'Arbitrage de CIMAC in Cameroon. Last but not least, we have with us today the pleasure of welcoming Balagal Madonada. She's the PCE representative in Mauritius. Our focus will be today on the role and the challenges of regional arbitral institution. To kick off, I will invite my esteemed panelists to share with us their unique perspectives, painting a divided picture of the current landscape. And following their assessments, we will engage in a couple of minutes interactive session with the public. And we decided together to divide today's topic in 3 different segments. We will start with the segment 1 about the role of the regional institutions, and I will give the floor first to Mr. Daduk, then to Victor, and at the end to Dalia remotely to present their views on the role and the effectiveness of the regional institutions. Please.
I'm first, is it? Yeah. Right. I do have slides. I think. How do I control that? Did I send slides? No.
Yes, the slides they have.
Never mind. Let me start off with by saying that this century is the Asian century, and perhaps it will be also the African century, because the American century is over. Before that, it was the European century. So I think the belief that we are going to have tremendous economic growth and prosperity, particularly in Asia and perhaps in Africa also, because these 2 continents have the young population growing very, very strongly, and then a lot of industrialization is going on, and that actually leads to how do you actually make that economic growth smooth. So it calls for structures. One of the ways that these structures, it has to be a semi-legal structure to resolve disputes. And one of these things that you see a phenomena that is happening in Asia is the proliferation of centers, arbitral centers. In fact, it is more than just a national airline syndrome. Every country expects to have a flagship arbitral institution. At the same time, it also expects to improve and become a hub to retain its own arbitrations or disputes, and also try to actually attract arbitrations from the region and perhaps internationally. So the real problem then becomes, if I can give you some statistics of how the things have changed. First thing is that the oldest arbitration center in Asia is CITEC, 1956. But compared to, let's say, ICC, is 100 years old, 1923. Maybe the Permanent Court of Arbitration is a decade earlier. But then look at CITEC. CITEC actually does more cases than ICC in terms of actual number of cases. Then in China, we have 247 arbitral commissions. In Hong Kong, we have 7. Then we move on to Singapore. Hong Kong was founded in 1986. Singapore in 1991. Now, if you look at the preference for arbitral seats, Singapore is now number 2, next to London. It's very, very interesting. The Asian seats, and Hong Kong is number 4. So the Asian seats are becoming important. They must be doing something right where international arbitration is concerned. But the real challenge in Asia, I think is similar to Africa, is how do you deal with the challenges of setting up a center, the difficulties that you have, and what are best practices that you have to do. We do face in Asia a number of issues, and some of the difficulties are international in nature. It is like you are trading with different countries. Their legal systems are different. People have different ways of doing business. A Chinese businessman does things differently because they would have state-owned enterprises. They are very, very large. Whereas an Indian business will do things differently. And they have different attitudes towards arbitration. Now, if you look at Asia, one of the things that's happening is that in certain regions, arbitration is totally controlled by the government. For example, or government-linked structures. For example, in China, CTEC is set up by the central government, and then the other arbitral institutions are set up by state, provinces, and also cities. In India, it is completely ad hoc. They only have, the main center is now they're calling it the Indian International Arbitration Center, and then each regions are coming out with it. Now, the challenges that Asia faces, even Southeast Asia, we're having the same. We have particular nation states that provide services for international arbitration, but the rest of it, just like in Africa, will have a lot of domestic arbitration. So the main thing is that you have to separate it and deal with it. That how do you handle domestic and how do you handle international? And I think the most important thing is to retain your domestic arbitrations. The way to do it is some of the things that really come up is first the issue of appealability. Appealability, when I say appealability, is that the lack of being able to appeal an arbitration decision or the slowness in enforcing an arbitral decision. So you have this thing that actually affects the confidence in arbitral institutions. There's also things like digital migration, and then what is the best practices that users want? Because many of the users are not familiar with the process itself. So you have to build capacity. So that is among the challenges that you have. Now, again, the other problem where institution in Asia would face is what is the type of rules you have to use. And the rules, there are many types of rules. Of course, the most famous is arbitral arbitration rules, which actually the model law is based on. In fact, the model law came about from the ALCO, which the Asian African Legal Consultative Organization proposed to the UN, the UNCITRAL. They come out with a model law in arbitration. It actually started in Asia and Africa, the idea itself on the model law. Then you have what is the rules you choose. If you go to, let's say, Singapore, the rules are very prescriptive. They are very like ICC. ICC have terms of reference and all these things. Very, very highly sophisticated. But if you're doing a domestic arbitration, you don't need that kind of sophistication. So I think that is where the complexity of the rules, the moment the rules become complex, the cost goes up. Because you need people who can interpret and deal with it. Then the other problem generally is speed and efficiency. In Asia, we have the same problem. Chinese arbitrations are known for their speed because they truncate their evidence taking and they have a different way of doing things. Indian arbitrations, I've said on Indian arbitrations, it takes years until 2015. In 2015, they amended, this is the one example of statutorily intervening to change the arbitral process. You must finish an arbitration domestic in 12 months or 18 months with extension with the permission of parties. That applied to international. Now it doesn't apply. But because of that, the arbitration speeded up. So the real issue is that it is not uniform. And then again, The other problem is that when you set up all these institutions, there's issue of public perception. Public perception is sometimes there is a lack of confidence. The lack of confidence comes out from two things. One is the institution is not known. Two, people don't know the process. They think, sometimes they confuse arbitration with other forms of ADR. And there are many forms of ADR. Some are rights-based, some are interest-based. So that is also an issue, that awareness thing. I think they only go to understand the process when they get the dispute, and it's a bit too late. And then suddenly they find it's very, very expensive. Then the issue in Asian centers, again, do you use a local center or you use an international center? ICC is there. You have SIAC very aggressively. They provide services at a sophisticated level. Then you have the other people who may put in a ICC clause and realize it is not actually worth carrying it out. Now, basically, all these things go towards boosting economic growth and trade activity. Now, what is happening in Asia, if you look at it, people are moving away from pure arbitration. They are moving towards mediation. They are moving towards statutory adjudication in the construction industry. They are moving away. So basically, then you're finding that UNCITRAL in 2021 rules came out with the expedited rule. Well before that, people were already doing expedited procedures in Asia, so that to handle smaller disputes. So I think that again becomes, there are a lot of things being looked at in Asia. For example, in Switzerland, you have CAS, the Court for Arbitration Sports. So sports arbitration is quite big in Europe. But everything from Asia and Africa and all over the world ends up in CAS. So I think one of the things that is happening is that we are starting to form our own structures, that selection of sports disputes are going to be handled by arbitration in the various regions. So you are seeing people, Bahrain, Oman came out with the sports rules. We have come out with sports rules. India, they are looking at it. So a number of things are happening. The other thing that is happening, specialized arbitrations. London dominates with LMAA for maritime arbitration. So what is happening now in Asia is that Asia has started to form its own maritime arbitration, although they are not getting the traction that they deserve. But what will happen, because 50% of the cases in London Maritime Arbitration Association is actually Chinese. Mm-hmm. So the moment you get 50% Chinese, the Chinese will think, why should I send the cases out to London? I'm quite sure the Africans are also thinking the same way. Why should we send our cases to somewhere else? We try to solve it within there. So I think once you start asking those questions, it starts to this one. Now, I want to talk about the centers itself in Asia, how it's handled. There are few ways of having centers, and this is the real challenges. What is the model you choose? Now, you can choose, first one, ICC model, which is linked to a chamber of commerce or chambers of commerce, and then you set up a company limited by guarantee. Mm-hmm. A lot of people also set out their own private arbitration centers. Then you have other places like China, they tied back with the government itself. And the government sets up the structure. It could be under charter or a statutory arrangement, but it is controlled and funded by the government. And the third way is international organizations, fourth way. International organizations like the PCA, like my center, where it is designated as an international organization with the immunities and privileges so that it is independent from the government. So these are the challenges that in Asia we are facing. So I think I will stop there. I think I've gone too much. Sorry.
Thank you.
I lost my slides. Sorry. I think it was more structured with my slides.
Thank you. I think we will distribute the slides again with the delegates later. Thank you for this overview on the practices, the best on the best practices in Asia. And now we go back to Africa and give the floor to Victor Mugabe, who is representing the Kigali Arbitration Center. Please, the floor is yours.
Thank you very much, Sami. In fact, I won't differ from what Professor Sondra said about the arbitration practice in Asia is concerned, because Africa is actually experiencing the same situation, though I can say that the arbitration and institutional arbitration in Africa is quite younger than the Asian one. As we may know, past and recent researches show that more than 80% of the arbitration disputes are resolved through the institution. So I mean arbitration administered under the arbitral institutions, while the less than 20% are administered under ad hoc arbitration systems. So those figures already show that there is need to invest in institutional arbitration, but with clear strategies to make sure that the system really well functions. That led to the proliferation of the arbitration institution on our continent, as the recent surveys show that the continent accounts nearly 100 arbitration institutions, but how many are functioning?
That's true.
So I think Professor Emilia, who was here yesterday, she might have left today, she has conducted surveys, and she shows that the continent counts that around maybe 10 or even less of arbitral institutions that can be said to be really well operating. So those institutions that have been showing that arbitration is really functional on our continent have been initiated by the Chamber of Commerce, private sector, or business community, and in most jurisdictions were created with less support of the governments or policymakers or even the judiciaries from those jurisdictions. So far, we can say that at least those that are really well functioning are really doing well, and they are really showing that arbitration, they can prove the opposite of what the Western or other, I can say, most advanced arbitral jurisdictions saying on the bias and negative perception on arbitration institutions are concerned. But, as I said, there is still a very long way and complicated long way to go by those institutions, including mine, the Kigali International Arbitration Center. So, today, for an arbitration institution to succeed, it has to reflect a very good reputation internationally. So that good reputation is the challenge that African arbitration institutions are facing currently. So it means we still have a long way to go to create that good reputation, and the reputation, as you may know, it takes long, yet the institutional arbitration in Africa is very young. I mean, most of the institutions are less than 20 years, with the exception of Cairo, which is now 44 years old, but others are relatively very young. So we still need to work on that. But how are we going to do that? So what I'm going to say is the experience and best practices that we have to showcase here that maybe my institution has done to be at where we are now. So the institution is only 11 years old, but we've managed to bring all the relevant stakeholders on board. The institution is a private sector-based institution, but for it to succeed, and which we would recommend other institutions in arbitration in African continent to do, is to make sure that strategically every relevant stakeholder is brought on board. First of all, the first stakeholder is the government. So an arbitration system being governed by good laws, good rules, I don't know whether best arbitrators, it cannot succeed if it does not have the support of government. The support I'm talking about is what I can call the political support. Is really the system functioning in a friendly political environment to attract the arbitrators, international arbitrators, and to attract the seats in that jurisdiction. This is something that really we have to work on. So I know that those institutions are led by well-educated people, high-profile people. It's now up to those people that can really convince the government to support the system in that way, by even showing to the government that the arbitration, it's a tool for attracting investment and business. It's not only a tool for access to justice. So the government, the countries can benefit for well-established arbitration system. The government also are there to support in establishing conducive legal framework and establishing some other basic infrastructures. Here I'm talking about like infrastructure that concerning the security, transparent governance, easing people to travel in those countries, so investing in hospitality. So, those kind of infrastructure that really supporting the government. But the second stakeholder that is very, very, very important is the bar association. The lawyers and the in-house lawyers are the ones that really prepare the contracts. So they need to be educated and to know that the arbitration is really the most effective way of settling commercial disputes. And judiciary, if we don't have the support of the courts, state courts that deal with the challenges and support in the different stages of arbitration, we need the courts to support us. Under the Center of Kigali, what we did is that initially when the center was created, the initial training brought together the lawyers, the arbitration practitioners, and the judges together so that they can understand the relevance of the institution. And today, at least, we are really benefiting that support. Other stakeholders are like the academia who are doing researches, but also who train the young or future arbitration practitioners. What we are now doing is to make sure that arbitration is included in the academic curricula at the university level. But also we recommend specialization. If now we are discussing with the university, different universities in the country to establish a master's program on arbitration, because the specialized people that we have now have done their studies abroad. So why can't we establish the same system in the country? So I think those challenges that it's a long list of challenges. I think if we try to address at least those ones that I have just said, that will contribute to tackling the bias that the outer Africa has on our arbitration system, we shall really overcome them. So the list is very long. I'm going to list them, but during the discussion we may list some of them. But it's now high time, because even the existence of the African Arbitration Conference, like this one, the event like this is also one of the strategies that now Africa is taking to overcome the challenges that you have. And that's why yesterday in the AGM we are calling people really to attract people, encourage them to attend these conferences, because it's here where we discuss challenges, and when back to our jurisdiction, we implement the recommendation that we get from such kind of conferences and idea and exchange that we get from here. So I think I can stop by here. Maybe we may supplement on what I said during the Q&A session.
Thank you, Victor. Thank you, Thank you very much, Victor, for having this. After the first Asian perspective and the Kigali perspective about how to succeed, how to make arbitration effective. And now I think we have the link with Dalia. I got the message from her. She's in the waiting room, and can we? Okay. Dalia Hussein, she's the Deputy Director of the Cairo Regional Center, and she will be providing us with the Egyptian perspective from Cairo.
Thank you very much. Can you hear me first?
Yes, we hear you.
Okay. So thank you very much. So yes, I followed the sessions this morning, and I followed with great interest what was said by So I think the most two important things are the neutrality and independence of the institution. And so on the other side, the role of the state courts.
I will ask you a question about the collaboration between institutions. The collaboration. Collaboration.
Okay.
I will ask you.
Okay, no problem.
Because you are best placed for that.
Thank you.
How the institution should
Thank you very much, Talia. We had three different perspectives about the role of the regional arbitration institution and what does it take to make a regional arbitration center effective and successful. Maybe we have, Mike, and we have still time for one question or two questions, either from the audience or any comments from my panelists about this topic before moving to the next topic. If not, we can move. Do you want to make any comment on the same issues? Svetlana or Bala? If not, okay. If not, then we move to the next, the second segment of our session. Is there any need for the Regional Arbitration Center to collaborate? Collaboration between Regional Arbitration Center. And we have here two speakers. They both will be remotely. I think we will succeed to join them. Lina Lohr from Durban. Again, she was supposed to be with us, but unfortunately she couldn't make it on time. And Lina can join us remotely. No? No. Okay, Lina cannot join. Unfortunately, the technical issues with Lina to join us. Sylvie, do you have any information from Lina? No. Okay. Then I will ask Fulmi from Lagos to join remotely. Okay. While waiting for Lina and Fulmi is here. Okay, Fulmi is here. Great. Fulmi is with us.
Can you hear me?
Yes, we can hear you, Fulmi.
We thought you lost her.
We can hear you, we can see you, but we can hear you.
I can't hear you now.
Okay.
But I will try my best.
Please.
So I have a problem, a technical problem.
But we can hear you, Fulmi, if you want. Okay, here you are.
Follow me, sorry.
Yes.
Very difficult, but it's really fast. So,
Thank you.
for giving me the floor. I go straight to the point. It has been said by the previous colleagues that there is a proliferation of arbitration centers, but how many really function today? So for me, I would like to share the approach, the strategy of CNRG, Centre de médiation et d'arbitrage musical, of arbitrators' nationality. It's very international. We have arbitrators from Africa and non-Africa. We have people from various countries in Africa, Cameroon, Benin, Senegal, Ivory Coast, and also from Europe. We have France, we have Switzerland. We also have openness in the diversity of skills and profiles. We have lawyers, non-lawyers, accountants, engineers as arbitrators. We also have it in the gender diversity, 30% women versus 70 for men. The openness is also shown in capacity building. We have been focusing a lot, as I think Victor said, on building referee capacity. For that, we organize very regularly courses, short courses, as well as practical training for arbitrators in partnership with Centre d'arbitrage de Paris. We also organize training with SOAS and Professor Emilia. And right now we have a pro bono trainings that we have managed to organize with well-known, well-established arbitrators worldwide. We also try as much as possible to cooperate with other centers or bodies, and recently we sponsored the NAS Cameroon Arbitration Week, which is managed by Julius, who I think is there with you. So all of this just meant to say that we wanted from the beginning to position the center as a reliable, trustworthy, professional reference center and open to not just national but international labor. Now, what are the next steps? We first got our basic rights, but now what are the next steps? The challenges were presented before, so a lot has already been said. I don't want to mention that many transformations are on the way. We have as business relations and investment progress on the continent. We have, in light of the entry into force of the African continental free trade area, we think that arbitration will further develop naturally on the continent. We also have, in addition to that, the protocol on rules and procedure for the settlement of disputes between states and also the investment protocol. All these should generate an influx of proceedings and opportunities for the many centers that you mentioned.
Thank you, Lina. Thank you. Yes?
To get there, you have to get prepared. So the question now is how to get prepared. Can we individually, as centers, tackle all these challenges? Can we see all the opportunities coming individually? Or what does it take? How can arbitration strongholds emerge in Africa?
Thank you for the question, Lina. Thank you. Thank you. Lina, I think it's time is over. The time is over, Lina. Thank you. Thank you very much. Maybe, I think I don't think that Fulmi can join us. In the absence of Funmi, maybe I can ask one or two questions on the same issue, on collaboration, to our panelists, maybe to Bala or to Datuk. What do you understand with collaboration between centers? What do you understand is maybe supposed to have joint events only, or maybe even go and tell the father to have to share information or have the same databases on arbitrator? What do you understand with that, Bala?
Thank you, Sami. I will base my answer on cooperation agreements that presently exist between the PCA, the Permanent Court of Arbitration, and regional institutions like the Nairobi Center for International Arbitration and Kigali International Arbitration Center. So when we talk about cooperation with the regional institutions from our perspective, we talk about knowledge sharing and knowledge exchange. KIAC has a very good understanding of the Rwandan market, for instance, or the Eastern Central African market. And in instances, let's say when we need to appoint arbitrators, when the few instances that the Secretary General needs to appoint arbitrators, I would rely on the advice of, let's say, the Secretary General of KIAC to consider who would be an appropriate candidate, who features in KIAC arbitrations and such things. And also in terms of knowledge sharing, we've had a few training sessions with different regional organizations in order to build capacity and to pay some attention to such things as investor-state arbitration and state-state arbitration that may be lacking as compared to contractual arbitration. And another important bit also is, especially during the pandemic, where witnesses are not able to travel, or they're not able to have their own connections at home, their own virtual connections at home, and that will be part of my presentation. We have relied on both KIAC and Nairobi Center for International Arbitration to provide us with facilities for witnesses or for counsel to connect and be able to participate in virtual hearings, in online hearings. Somebody said they do not like the word virtual hearings. So cooperation goes many ways. It's not just, north-south, as they say, that we're just getting things, or south-north. We're not just getting things. It's just knowledge exchange that comes from both sides.
Thank you, Datuk. What do you think about the same topic and being here from Asia?
Actually, it ranges. Cooperation, collaboration can work from a very small scale to a very large alliance. Let me start off with simple things. We exchange information. A lot of centers exchange information. We exchange information about arbitrators. We exchange information sometimes about parties, especially when we have difficulties. I think in Asia, we have a way of talking to each other. Sometimes, we have arbitrators that we think are rogue. So there is a system that we have actually, we do talk to each other. That is on a smaller scale. The other one is, for example, hearing venues. Sometimes you need to have a hearing venue in a particular jurisdiction, and you need to have an arrangement. So recently, we had to hold a hearing in China, and we contacted CTEC to allow us to use their hearing because it was an administered arbitration. So we did that. So it happens, that is on the smaller scale. And then the other one, with Kigali, I remember we did training. We had an expertise in statutory adjudication, and we had a course. We took the course to Kigali, Africa. We trained 50 people, and we empaneled them on our center. So we recognize, we get that skill set. The next one is the Grand Alliance. The Grand Alliance actually is to try to change. I give you all one example that we tried to do, which did not happen, but I thought it could have happened. Okay. Everybody knows about the Belt and Road, China's Belt and Road. In 2013, President Xi announced in Indonesia that he is going to create this connectivity throughout the world, recreating the maritime and the land route, and involved massive investment, and they had the construction powers, they were going to construct. But of course, there's going to be a lot of disputes. You're going through all these countries, 100 over countries, to reach that point. I think at that time, all of us were thinking, how are they going to resolve the disputes? And of course, I think most people would want to structure the way we want to. In fact, I think we were talking to the Chinese at that time, the ALCO centers, to actually set up an integrated system that allows a uniform set of rules, and we were talking to them, and in fact, my center changed the name from KLRCA, which is Kuala Lumpur Regional Center for Arbitration, to the Asian International Arbitration Center in anticipation. But you know, these kind of things take a lot of effort, and there has to be a lot of trust and cooperation. So I think, you know, those kind of alliances could possibly happen, and that is another form of collaboration that happens. You know?
Thank you. Good. Thank you very much, Datuk. We have good news. Funmi is online, and she can join here from Lagos. Thank you, Funmi. I hope you've heard the discussion we had about how to collaborate between region and center. Please, the floor is yours.
Hello, everyone. Can you hear me?
Yes.
Okay, excellent. Hi, hello, everyone. It's a pleasure to be on this panel, and thank you to the President for having last year. Yes, so the issue of arbitration is one that is a big deal for us, if I could use that word. And I think that almost everyone on the panel probably has personal engagement as you are either inviting, the executive secretaries or admin persons or agents or collaboration. We strongly believe that it's important for African institutions to work together. In fact, for ourselves, we have a vision that we're able to come together and actually create synergies, operational synergies that we stand a better chance of putting up options to the existing arbitration institutions, meaning that well, everyone says that African institutions should retain arbitrations that arise from African transactions. We know that that's not the case in the United States, and a lot of times cases go to institutions in Europe. We believe that if there's more synergy, more collaboration amongst African institutions, then we have that kind of active retaining work. And I think that's for many reasons, because we also know that a lot of times, from outside of people see Africa as seen as just one continent. There is really a lot of communication between whether it's Nigeria or Rwanda. So if we have, a strong institution, and it may not necessarily be one unit institution, but operational collaboration amongst ourselves and foreign investors, international corporations, they need to see that one strong African institution. I think it will go a long way in achieving what we all hope to achieve, retaining this disputes in African institutions. And for ASEA, we are driving this significantly. We're actively creating cooperation with institutions. We have cooperation agreements, out of Mauritius, out of Tanzania, out of Nairobi, in Ghana, and then also out of the continent. We just signed something at the PCA, today. And it's all, central to what we said that LASEC is maybe even the organization of the panel, but we just see that for both we need to come together, share the list of jobs, which is what's happening with that combined list of something, have workshops for institutions. I know we've spoken about that, where we're looking at our rules, challenging our rules, looking at how we ensure that all our rules are, complementary to our and are definitely best practices. And then, someone spoke about collaboration where you have even a district that is administered by one center, but it's actively being gone out of another place just for logistics reasons. Those are the kind of things that we should start doing. Baby steps towards creating a global consolidated rights of institution. It started a last action for the continent, and we really think that because I think we definitely help in developing arbitration.
Thank you. Thank you very much, Funi, for your contribution. Thank you. I think we shorten up. Thank you. We now move to forward, and the rising prominence of data protection and cybersecurity is paramount, ensuring the privacy of the entire arbitration process. To tackle this issue, we have two speakers on segment 3, data protection and cybersecurity. We have Bala and Stevilana from South Africa. The floor is yours to address this issue.
Thank you very much, Sami. So I'll change gears a bit and talk about online arbitration with a focus on the practice of the PCA and what we have been paying attention to particularly. When we talk about online arbitration, of course, we talk about two things. The submission of documents, which already happens virtually. We either send them by email or they're transferred using a secure file sharing platform. Nobody anymore physically presents any documents to say, you know, I'm initiating an arbitration or I'm requesting for the appointment of an arbitrator or designating an appointing authority. So that has already moved, the document submission bit has already moved virtual and online entirely for the PCA. In terms of hearings, the hearings themselves, we've had, I think, about 65, more than 65 cases that have entirely been conducted. The hearing has been entirely conducted online. These have been purely investor-state and contract-based arbitration. We haven't yet had any state-state arbitration that has been held online, maybe for the future. In terms of legal provisions, the UNCITRAL rules and the PCA rules already support, we already know this, they already support online arbitration. That there is a provision under Article 2 or Article 18 or Article 17 that the tribunal has the freedom, has the discretion to conduct a hearing as they will, you know, as they deem fit, of course, subject to the contribution of the parties and to the position of the parties. And because of that, we have been able to have this online hearing. But then the question has arisen, especially towards the end of the pandemic, is there a right to a physical hearing? And ICA, I'm aware, has done a bit of research on that, quite a bit of research actually on that, on whether in international arbitration there is a right to physical hearing. The general preliminary conclusion is that there isn't a jurisdiction that at the moment has a right to physical hearing in international arbitration. However, as Judge Wallace pointed us to earlier in his speech, the rules of evidence differ from one jurisdiction to another, and at the end of the day, it's very important to do due diligence and see what the law of your seat provides for. Does it provide for a right to physical hearing? Then you probably should have a physical hearing as opposed to an online hearing. Regarding logistical questions, there's a few matters that we consider. Of course, the first is the platform. What platform should you use? And in terms of platform, you have to look into the security of the platform, the simplicity of the platform, and in terms of simplicity, you know, such things as that we take for granted, unmuting on the Zoom platform or muting or turning on and off your video, they have to be as simple as possible. You can't have multiple steps for an arbitrator to participate in an online hearing or counsel to participate in an online hearing. And in terms of platform, we also look to have an option that gives us a recording feature. The recording feature is what will be used by parties in addition to the transcript to try and to review the transcript of the hearing, to prepare post-hearing briefs and so forth. And again, in terms of platform, there's need to have a platform that allows for electronic presentation of evidence simultaneously with a translation channel, simultaneously with a transcript channel. And there are a few, there are not too many, there are a few service providers in this regard, and we've been able to rely on those to provide online hearing services. Again, in terms of logistics, to ensure that the parties and the tribunal are adequately ready before the hearing, we usually have a pre-hearing test that happens about maybe a week or 3 days prior to the hearing. And it's at that point that we test the stability of your connection, the security of your connection, and such simple things as your video focus, your audio, and all these things. In a few instances, we've had problems with individuals' connection, which has allowed us then to rely on cooperation agreements, what I was pointing to earlier, with KIAC and with the Nairobi Center, and have individuals whose connections are not so stable to be able to provide either their witness statement, their witness evidence, or their testimony from these facilities that have more stable connections. Another logistical question that we look to is a technical failure protocol. What happens when in the middle of a hearing, in the middle of counsel being on their feet, or in the middle of the witness giving his or her statement, there's load shedding, or there's a power cut? And all those details are things that we look into to ensure that there's efficiency, because at the end of the day, whatever mechanism you choose, whether you choose an online platform, whether you choose a physical hearing options, it has to be efficient, it has to be reliable for the parties to use. And increasingly, now I'll move to the other part of my presentation, increasingly now we see questions and concerns of data protection and cyber security. For data protection, the question is, there's so much data, of course, that flows from the tribunal to the parties, from the parties to the tribunal, with the administering institution as well. And then there are other individuals and institutions that are sort of in the shadows, like the secretaries of the arbitrators. And in this instance, I don't mean the tribunal secretary, literally the secretaries of the arbitrators, because most of them tend to have their own support staff in their law firms, or the secretaries of counsel. They also get to handle some of this information. And when you start thinking about how to protect data that should be confidential, because arbitration is confidential, when you start thinking about this, you have to consider all this really wide aspect to arbitration information flows. And you also have to consider the data protection laws of the seat, because that definitely becomes important, and also other data protection laws that you may not naturally appear as a, to give an example, you might have a seat in your seat is Nairobi, or is Kenya, and your data is flowing from the EU, for instance. By virtue of your data flowing out of the EU, the GDPR applies to you. That data protection regulation applies to you. And as arbitrators and as arbitral institutions, we have to be aware of this, and we have to see how well to protect data to ensure there's not any data leak. And one way that we increasingly see tribunals approaching this question is in the terms of appointment or procedural order number 1. You will see that there's a provision that says counsel and the tribunal and the arbitral institution, the PCA or whatever, will pay attention to all these particular provisions and requirements, such that the burden is on each of us who has signed the terms of appointment to ensure that we abide by the regulations in order not to have any criminal or civil liability on that front. In terms of cyber security, I know the next presenter will go into detail about that, but the platform that you use, whether it's for the transfer of documents or to conduct the actual hearing itself, has to be secure. And security is not just physical security in the sense of who is in the hearing, who gets to hear what is going on. And somebody gave us an example of how well into a hearing, well into a case management conference, they realized that there was an additional person in the room who should not be there. And those are things that sometimes we fail to remember to consider, but we have to pay particular attention to that, especially if we want to have a reputation of being reliable and efficient in terms of administering online arbitration. In case useful, I'm aware that ICA has a protocol on cybersecurity that would be useful when we are preparing our terms of appointment or procedural order number 1. I'm also aware that they have a roadmap on data protection that will also come in handy on that front. And I will not bore you further with online
Thank you. Thank you very much, Bella. Thank you. Our last today's speaker will be from South Africa, Svetlana from the AFSA, about the same topic, please.
Thank you, Sami. I will delve today into the intricate layers of cybersecurity, data protection, and online arbitration management. And more specifically, I will try to shed light on the immense responsibility and accountability that rests on the arbitration institution in this digital age. From the standpoint of the arbitral institution, data integrity is not mere buzzword. It is cornerstone in its duty to all shareholders that is involved. And as we delve deeper, we will see how crucial secure data transfer and data storage becomes. And more importantly, to understand and acknowledge the potential liability that arbitration institution might face in the unfortunate event of that data breach. Can we move on the next slide, please? In this slide, essentially, encapsulates the commitment and the challenges associated with the safeguard on the data integrity. Here, please, next slide. Here, I'd like to talk you to the same significant cyber events that have implication for the world of arbitration, followed by the advances on the cybersecurity. Perhaps maybe of you will remember in 2021, the global community when witnessed the significant shake-up of the Maze ransomware. And what impact the law firm across the globe. But this also highlights the threat of the cyber attacks in our sector. Forward to 2021, in the Brazil case, there was raised the eyebrow due to the concern over the cyber interface in the arbitration proceedings. Similarly, significant incidents like the targeting the PCA website during the China-Philippine arbitration, probably you will remember, but also the surveillance in the Lebanonco Council in the Lebanonco versus Turkey arbitration. And in all these cases was underscored the vulnerability of our system. In response to all these challenges, the Arbitration Institute of Stockholm Chambers launched the platform in January 2021. Please, next slide. ACC platform acts as comprehensive online repository, streaming communication among the parties and critically minimizing the risk associated with the data breaches and email interceptions. Not to be outdone, Hong Kong International Arbitration Center also introduced in 2021 their Case Connect platform, which is developed in tandem with cloud-based solution and banking-grade encryption, and also with rigorous surveillance. AFSA is also actively looking at such innovation and considering upgrade of our current online case management system, emphasizing the global trend towards enhancing the global security. For arbitral proceeding, next slide please. For arbitral proceedings, to maintain the integrity, it's imperative for all stakeholders to adhere to essential cybersecurity practices. And this includes, but is not limited to this, to use of secure transfer methods, documents encryption, multi-factor authentication, malware protection, and capability for remote wiping. Next slide. And the next slide. From institutional standpoint, the emphasis should be on the robust online case management platform. Thank you. Stringent security protocols, regular audits, secure communication channels, and consistent training for all users. Additionally, the need for external assessment such as penetration tests and comprehensive privacy impact evaluation is paramount. On the subject of recommendation, the IBRAM Hong Kong ODR platform suggests that data should be encrypted, stored in the trust data centers, and protected using multi-factor authentication. They also advocate for DDoS protection, firewalls, and 24/7 monitoring of the network threats. South Africa's stance on cybersecurity regulations aligns with the global benchmark. We adhere to standards like SANUS 27001-2023 and ISO and AEC 27001-2022, emphasizing the importance of cybersecurity and privacy protection. For those keen to delve deeper, there are a plethora of guidelines and protocol available, such as ABA Presidential Task Force Cybersecurity, the ICC Commission report on IT international arbitration, as well as ACA report number 6. In conclusion, talking about the cybersecurity, in this ever-changing realm of the cybersecurity, the exact boundary of arbitration institution duties in guaranteeing the cyber integrity in their arbitration still remain undefined, meaning that there is still lack of normative standards and cohesive measures in this regard. But this is essential for us to stay vigilant, informed, and proactive. In the realm of international arbitration, there is growing emphasis on data protections as well, especially when we're talking about the document production. Given the pivotal roles of arbitral institutions that is played in data management, there are various data protection regulations that need to be considered. Arbitration institutions are not just passive actors with regards to data they collect and control. In fact, they are internet service provider, and this needs to be considered because of the service they provide as online repositories. This includes all set of possibilities such as ensuring system availability, maintaining data integrity, and of course, protecting data that they possess. To bolster data protection within arbitration institution, there is a push to empower data protection officer role to ensure compliance with the data protection regulation. Also, in doing so, the arbitral institution need to address the questions such as what personal data they collect, why, and under which laws. As for the governance recommendation, strict data policies are a must. Staff access to platform data should be controlled and limited. Any deviation from the standard data request should be passed through stringent checks, and for reasonable transparency. All files transfer need to be lodged securely using blockchain-enabled transfer-resistant storage. In conclusion, talking about the data protection, in this evolving landscape of international arbitration, driven by the relentless digitalization, mandates arbitral institution to be forward-thinking. But this is not just about leveraging technology. It is also about doing so responsibly, ensuring strict adherence to data protection regulations is not merely a legal obligation, but this is also a testament to arbitration institution commitment to integrity, trustworthiness, and safeguarding all stakeholders' rights. When we're talking about online arbitration management, here I would like to walk you through some of the top platforms recommended by ABA to facilitate your online arbitration services. For audio-video conferencing platforms, there is, on the slide, are this platform that is on the forefront. Efficiency in organizing documents is crucial, and in arbitration recommendation from International Bar Association, this is the following platform that they suggest. When we're offering online platform on arbitration, the arbitration institution need to ensure as minimum they have breaking rooms for private discussions, efficient document sharing tools, screen sharing option, note sharing or editing capabilities, recording feature, and channel for group and individual chats.
Svetlana, I think I've been asked to ask you to
Okay.
because we're out of time.
Oh, no problem.
Okay. It's okay if you have still to finish. Okay, because I think the slides are available at the platform. They are really very informative. The Svetlana slides, you can have them on the application for review. Sorry to interrupt you again, but this is my role as the moderator. Thank you. I would like to thank again all the panelists, whether the present or those who are been participate remotely, and I give the floor to the control tower. Thank you. Thank you. Thank you so much.
Thank you very much, Sami. You're a very brilliant panel. I think it's always a big challenge to hold your panel after lunch, and in particular on a Friday afternoon. Most people in here have better things to do on Friday afternoons, and that include refreshing or winding down, as they say. But that is part of the agenda for this afternoon, and as I promised earlier, I'll be releasing the address where we shall be adjourning for the item 11, refreshment, generously provided for us by Weber Wenstel Law Firm in Cape Town. But before that happens, I'm going to invite the keynote speaker number 2. Remember today we said we had two keynote speakers. The first one, Judge Malcolm, spoke this morning. And the second one is Professor Raymond Ranjiva, who is going to speak to us. And then after that, there will be presentation of a present, which I'll invite Vlad to be ready with it. And then I think we shall hear very, very briefly from the young people who will be telling us what they have to do tomorrow in the morning. And then after that, I will suggest that people just go straight to the rendezvous point where we will be meeting for the refreshments. The reason being that we will expect people to retire earlier because we still have tomorrow to deal with. And then tomorrow evening is even heavier drinks session. So when you go out to drink tonight, please do so moderately. I am going to invite, sorry, thank you. Thank you so much. Well done. I'm going to invite Professor Ranjiva, and just by way of background, who he is a retired professor of public law and political science, University of Antananarivo, Madagascar, from 1972 to 1991. He's the honorary president of the Malagasy Academy 2021 and a member of the curatorship of the Academy of International Law 1998 to 2022. President of the African Academy of Religious, Social and Political Sciences, and is a founding member of that organization. He's a member of the Institut de Droit International et Académie des Sciences d'Outre-mer, 1994. Former judge, 1991 to 2009, and vice president of the International Court of Justice, the period of 2003 to 2006. He's a former member of the International Court of Arbitration of the International Chamber of Commerce in Paris, 1998 to 2006, and also a former member of the Court of Arbitration of Sport, Lausanne in Switzerland, in 1998, from 1998 to 2002. Also a former member of the Committee for the Review of the Conventions and Resolutions of International Labour Office for the period between 2006 to 2022. Member of the formal Pontifical Council for Justice and Peace, Vatican, 2000 to 2020. There are other jurisdictional activities, including arbitration, journalistic, consultancy, and trade union activities. Diplomatic activities include bilateral and multilateral negotiations, settlement of bilateral and multilateral international disputes, international political or legal conciliations. We put our hands together for Professor Ranjiva.
Thank you too much. Unfortunately, don't say that they have to speak in French.
All right, okay, no, I do apologize. I should have said. You see, it's also a challenge when you read a very impressive bio like this, you're bound to forget some other personal things that you had to do because you're asking yourself, what have you been doing when others were achieving all these credentials? Professor is going to speak in French, and there will be simultaneous translation into English language. On your screen, there will be a QR code, and to access that, you can use your telephone, by the way, and there is a code to that which I can read out to you. If it doesn't appear on the screen as well, it is AFA 2023, so capital AFAA 2023. As he speaks, you will get the translation. You can either get it on your phone, read it on your, follow it on your phone, and you can actually get it audio, by way of audio as well. Professor.
Merci beaucoup. Thank you so much. Monsieur le Président, Mesdames et Messieurs, bonsoir. En prenant la parole ce soir, vous ne verrez aucun inconvénient à ce que j'exprime mes plus vifs remerciements à celui à qui je dois cet honneur et ce privilège de m'adresser à votre auguste aéropage que je salue avec respect, j'ai nommé Gaston Kenfak. Je me contenterai ce soir de partager très simplement avec vous des considérations tirées de mon expérience personnelle. Mais comme enseignant, je ne peux pas me limiter à vous délivrer des informations encyclopédiques que vous trouverez d'ailleurs, ailleurs, grâce aux nouvelles technologies de communication sociale. Je souhaiterais briser la logique formelle, la tentation naturelle du juriste, enseignant comme universitaire, pour parler de cette aventure dans la réalité de l'arbitrage et vous amener à revenir à la réalité des faits. Il faut remonter à la création en 1919 de la Chambre de commerce internationale, au sein de laquelle a été placée en 1923 la Cour internationale d'arbitrage. La CCI et la CIA s'inscrivent dans la pensée internationaliste du traité de Versailles de 1919, à une époque où triomphait la pensée libérale en politique et économique et sociale avec la Société des Nations, l'Organisation internationale du travail. Ensuite, cette création, ou ces créations, reflétaient la foi en l'avènement d'un monde de paix, avec le développement progressif du droit des relations internationales et l'institutionnalisation d'un mécanisme permanent de règlement des différends. Et, s'agissant de la CCI, on avait affaire à une organisation patronale chargée d'offrir à ceux qui le sollicitent, contre rémunération, des services. Et l'arbitrage international dans les relations d'affaires doit s'inscrire dans cette économie structurelle institutionnelle, le libéralisme. Ces mêmes paradigmes se retrouvent dans la genèse de l'arbitrage international en Afrique, dont nous avons, Gaston Kenfak et moi-même, écrit les premières pages lorsqu'il a fallu concevoir l'OADA. En effet, la création de l'OADA et de son système de règlement des différends commerciaux et relatifs aux investissements s'inscrit dans le mouvement de libéralisation économique sur le continent et de démocratisation de l'exercice du pouvoir politique. Cette double libéralisation était scellée par le recours à la voie conventionnelle intergouvernementale pour la consécration et l'adoption de l'acte constitutif de l'OADA. Ainsi, était confirmé par voie intergouvernementale le caractère privé de l'arbitrage international des affaires et des investissements. De son côté, la CCI a porté sur les fonds baptismaux l'OADA en partageant l'expérience de connaissance, d'expérience, pour assurer aux filleuls les meilleures conditions de lancement. Et à l'analyse, cette relation particulière des deux institutions illustre le développement, sinon l'effectivité de la mondialisation de l'idéologie, des normes, des pratiques et des usages dans les relations et le droit des affaires. Cette mondialisation dans l'ordre international contemporain, notamment sur le continent africain, pose la question de la confiance à l'égard de l'arbitrage international. Deux critères peuvent être utilisés pour apprécier la confiance à l'égard de l'arbitrage international africain: la base consensuelle de compétences des juridictions arbitrales et la porosité aux impératifs de l'Afrique. La triple mondialisation du mouvement général des fonds, des institutions et des normes ainsi que des pratiques a aussi gagné l'Afrique. Et la base consensuelle de compétences a été retenue pour envisager le mode normal de règlement des différends en matière d'investissement, en matière du droit des affaires. Et à ces considérations stratégiques s'ajoutent des facteurs qui expliquent le succès de l'arbitrage international en Afrique. Je cite: les difficultés financières des États, la marchandisation du recours à l'arbitrage lié à la multiplication parfois abusive des différends, quelquefois artificiels. L'arbitrage est présenté comme une activité commerciale dans l'intérêt principal des investisseurs, selon, en général, une opinion publique qui prévaut dans les masses médias africaines. En 2011, l'Australie a initié la contestation en annonçant l'exclusion des dispositions relatives au règlement des différends dans les traités d'investissement que l'Australie signera dans l'avenir. Et en Afrique, la remise en cause de la confiance a été initiée par notre pays hôte. L'Afrique du Sud a proposé une solution de continuité et annoncé la révision de la politique antérieure des investissements. Et une telle déclaration de principe ne peut qu'avoir des répercussions directes sur la confiance à l'endroit de l'arbitrage international. Ces différentes attitudes doivent être inscrites de manière pratique dans le projet des BRICS, dont l'objectif principal, et je cite, est la contestation de la gouvernance économique d'un monde unipolaire. En un mot, la mise en cohérence de la géopolitique et de la géoéconomie. La répercussion de la mise en cause conséquente de la confiance en l'arbitrage a déjà été concrétisée par l'Argentine, qui a refusé le paiement des coûts liés aux sentences arbitrales. Et ces discours déstabilisateurs doivent être traités de manière permanente. Il est urgent en Afrique que soient clarifiés les rapports consubstantiels entre l'institution de l'arbitrage et le libéralisme économique dont les institutions patronales sont les chantres qui y sont attachés. Le dépassement de la polémique idéologique signifie pour ma part le traitement de la question en justice et vérité de la notion de service assuré officiellement par l'arbitrage dans le règlement des différends. Il s'agit en réalité des coûts liés à l'évaluation de la prise en charge des coûts de la prise en considération de ce que l'Afrique du Sud a appelé le prix du développement, ou plus globalement la porosité au souffle du monde africain, pour reprendre les expressions du président Senghor et d'Aimé Césaire. Cette révision a une dimension comptable et mercantile, mais celle-ci ne suffit plus pour définir le procès légal et licite. Le droit des relations d'affaires implique normalement l'élimination de tous les éléments moraux philosophiques, ce qui signifie l'exclusion de ce qui n'est pas le droit positif. Et cette perspective technicienne du droit et le confort consécutif à l'approche purement technicienne du droit amènent naturellement les praticiens du droit à s'enfermer dans leur seule discipline. Mais les conditions actuelles imposent une transformation des mentalités et des structures pour permettre l'avènement d'une révolution créatrice d'un profit juste dans une mondialisation équitable qui fait l'objet d'un large consensus dans le monde international et dans le monde. À notre niveau et au niveau de l'arbitrage, il ne s'agit ni d'une agitation ni d'une propagande politique, mais d'un réexamen des interrapports entre le capital, la production, le travail et les échanges lors de l'évaluation et de la liquidation des préjudices liés aux différends. Tous ces enjeux ont un coût. Ils peuvent constituer alors des causes de différends et générateurs de préjudices. Et pour illustrer mon propos, je voudrais évoquer un cas concret. Dans un contrat, les parties conventionnellement stipule des obligations de faire que le co-contractant ou qu'un des co-contractants n'exécute pas. Naturellement, la tentation légale est de procéder à la compensation, ce qui est licite, légitime et légal. Pour ma part, j'ai un doute sur le bien fondé de cette compensation si on se situe dans une perspective juridique africaine. L'option préférentielle en faveur de l'obligation de faire, convenue dans l'option préférentielle en faveur de l'obligation de faire convenue dans le contrat, s'inscrit, à mon avis, dans la situation de l'économie africaine. Le déficit en infrastructure, en effet, et la priorisation des investissements structurants impliquent une méthode dynamique et différente. Et l'application automatique de la compensation risque d'apparaître comme une solution de facilité, à la limite dangereuse pour l'économie générale. Sur le plan normatif et institutionnel, la difficulté principale est relative à l'indépendance des arbitres. Car, s'agissant des arbitres, on envisage à la fois le parcours personnel et les conditions sociales de l'arbitre lui-même. Et il y a lieu de faire montre de discernement face au développement des fake news. L'intégration de l'arbitrage international dans la financiarisation augmente les risques de sa marchandisation croissante, c'est-à-dire sa transformation en produit commercial. Or, un tableau des interrelations structurelles entre les grosses firmes de conseil juridique et fiscal, les cabinets réputés dans la pratique de l'arbitrage et les entreprises de création scientifique et doctrinale dans l'arbitrage, ainsi que les institutions spécialisées dans la conquête des marchés, laissent en définitive une portion plus que congrue que l'on concède au monde juridique africain. À l'examen de la pratique et de la réalité, c'est moins une question de compétences scientifiques et techniques que de stratégie commerciale offensive pour la conquête du marché africain. L'étroitesse du marché africain pour les juristes africains explique l'expatriation des juristes africains qualifiés dans les pays du Nord, sans une contraction de la prise de part des cabinets internationaux dans la prise de part sur ce marché et sur les investissements. La clé d'entrée reste la porosité aux enjeux du continent africain et la difficulté à laquelle l'univers des juristes africains se heurte réside dans l'inégalité des armes pour la conquête des marchés. Ces considérations justifient le caractère urgent de la mise en place d'une stratégie de formation de haut niveau en matière d'arbitrage. L'information technique et économique concerne, à mon avis, l'approche administrative, voire purement bureaucratique, de la formation et de l'information. La question n'est pas d'indiquer ce qu'il y a lieu de faire, mais s'agissant de l'arbitrage, de conquérir presque moralement la légitimité de l'arbitrage international en Afrique. Et l'évocation de cette légitimité intrinsèque et erga omnes de l'arbitrage nous conduit à dépasser la simple vérité scientifique pour plonger dans une option sur une vision du monde. La conquête de la place de l'arbitrage signifie maîtrise de la philosophie de l'arbitrage, c'est-à-dire la prise de conscience des postulats qui sous-tendent les règles. La prise en considération de l'éthique est alors inéluctable en ce sens qu'il y a lieu de ne pas oublier l'éthique qui s'intéresse à l'examen des conduites humaines et des valeurs qui les guident. Car le droit n'est pas simple spéculation de principe se réduisant à la logique formelle, mais sanctionné par l'effectivité. Je vous remercie de votre patience.
Yet again, another fine keynote delivery this afternoon from Professor. Yes, George. Yes, thank you so much. Well done. Good speech. George, Malcolm had to leave, Wallace had to leave earlier today because of some family commitments. It was intended that both of them would have their gifts handed over this afternoon. Now, I know it's a very difficult time for us on a Friday evening, still hanging around when the refreshment is around the corner from here. But bear with us, it didn't be long. The young people said they had something to say, and being champions of diversity, equality, inclusiveness, and everything, we invite them to say very quickly what they want us to know.
Thank you very much. I know it's late. We've sat here through since morning. My name is Haman Omiti from Kenya. I stand here on behalf of the Young Members Group. We are a group of young arbitrators, members of the AFA. We want to first say thank you to the Secretary General and the board for accepting very many requests that we keep bringing to you. We assure you that those requests will keep coming because we are trying to ensure that we build a very vibrant group or team of young arbitrators across Africa that will help us ensure that the objectives of AFA are fully met. We also want to thank Sylvie for being there for us and putting us together as a group. I want to also thank some of the members that we keep coming to and requesting to be part of our monthly webinars. We have monthly webinars through which we discuss many issues on arbitration in Africa, and we've been inviting you. We will keep coming. Please accept those invitations because that's the only way you keep building us. But beyond that, we also request that to build capacity for the young arbitrators in Africa, please accept and hold our hands for the very important and complex international arbitrations that you handle. Please carry us along so that we learn a lesson here and there. That is the only way that we will ensure that the future of arbitration in Africa is taken care of. Lastly, I would want to announce to the Young Members Group that tomorrow morning we will have a breakfast meeting between 8 and 9 a.m. on the second floor. Kindly avail yourselves so that we can put our heads together and have a conversation. We will have it on a hybrid, so we'll also share a link for the young members who may not be here. But for those who are here, kindly make time and attend the meeting tomorrow in the morning. We hope to see all of you there. And for those who may not be members of AFA yet, but they are young arbitrators, you're also welcome. Please, let's see you there tomorrow morning. Thank you.
See, we've been kind, and in the spirit of inclusiveness, we give the young people the opportunity to speak, and they have talked about their meeting, and they didn't say whether us senior citizens are invited. Did they say senior citizens are invited? No. The seniors to come. All right. Sorry, did you say everybody or just the young people? Edward, stop giving wrong information. I heard him well. So some of these things, it's good we clarify them because we don't want to turn up in our with our gray hairs and we are told you can't come in now. So it's good we know. Okay, thank you all very much. We've come to the end of today. The official part of today is concluded. And as I promised, I have the address here where we're going to have the refreshments, which should really start now. And as I said earlier on, I encourage people just to go to the venue now, and everyone is invited, including the young people. And of course, the young people under the age of 18 should not drink alcohol when they get there. So the address is, I'll struggle with the pronunciation, but I will give it a go. Is it Haygrave Street? Haygrave Street, Convention Tower, Cape Town City Center, and Foreshore, Cape Town. I understand it is about 5 to 10 minutes walk from here, and you can go by Uber, you can go by any other means, and you will not take long to be there. In fact, the easiest way is to ping it in your Google Maps, and I understand it will take you there even quicker. So you're all invited there, and you can start making your way there. Remembering that tomorrow we start at 9 a.m. and if you could all be seated here at that time, it will be very much appreciated. If maybe just stay for 1 second, Vlad is coming up to. Yes, okay. Yes, Vlad is suggesting that you can just plug in the name of the firm, which is Weber Wenzel, Cape Town, into your Google map, and it will take you there, like I said before. I'm very impressed that nobody's in a hurry to leave, I wish we could just start, So please, I suggest that you start, how long? 1-4. Okay, 14 minutes is nothing. So anyway, I suggest that we just go there right away so that we will be back tomorrow nice and tidy in the morning to start off the remaining panel. The room again will be locked, but I suggest you don't leave your personal stuff inside.